I wasn't even aware at that point that Mr. Hales was going to do what he did yesterday evening and plaster that video all over YouTube. I kind of suspected he might do it.
We're back in hearing number 4, where Judge Craig DeThomas has interrupted my lawyer every time he's attempted to speak, and yet has not said one word when LIEnette's lawyer speaks. You think he's a little biased?
And in violation of our Chief Judge's Administrative Order 1.14, version 2. Despite that, he requested and obtained unredacted copies of the 1129 and 12-6 proceedings, and is now answering to contempt charges from the Chief Judge, since it's his administrative order, about what then ends up being disseminated and published on your client's YouTube channel.
Do you think you're seeing the unredacted hearing number 4 or redacted hearing number 4? Not a trick question. The answer is yes to both, because there's no difference whatsoever.
And so that's another consequence of there being additional time. And now I'm hearing this morning that a deposition has been provided on YouTube. And let me just ask the question, is it a video depo?
What other kind of information is gonna be on YouTube? Of course it's a video. You like how he's playing he don't know and hasn't been watching? We all know he's watching.
Well,
It is a video deposition.
it was improperly noticed as a video depo. It does not comply with the rule.
Well, let's follow the rules. That's why I'm asking the question, because there's a rule right on point, 1.310.
There is.
If anyone is foolish enough to not think that this conversation was pre-planned with Judge Craig DeThomas and Joshipu Silverman, as Craig DeThomas is going straight to the papers, I know there's a turd purgatory that needs all kinds of money. You can send all your money there.
And so the notice that was filed on January 15th, I believe it was, in the title, just the title, says Notice of Taking Video Deposition by Subpoena Ducis Tecum. Putting it in the title does not comply with the rule. You can put things in the title.
I've got the rule right here. Let's go to the family rule. 12.310, subsection B4. Any depo may be recorded by video without leave of court or by stipulation, provided you follow the following rules. A, notice must state in the notice it's to be video with the name and address of the operator. B, the court reporter must be stenographically recorded by a certified court reporter unless otherwise agreed. C, procedure must on camera identify the style, state the date, swear in the witness. D, custody of the tape and copies. The attorney requesting must take custody and be responsible for safeguarding the video.
If I could jump in right there, I did yesterday reach out to Mr. Shockett's office and ask him to provide me with a copy of the videotape, or the video recording. I guess nothing's on tape these days. He directed me to the court reporter indicating that they had custody of that and that I would have to obtain it from them. We had a spirited discussion about the cost of obtaining that.
It cost me over $2,000. I am the legal owner of that media. If you understand ownership in that way, whether it's a video on YouTube, I own this video. It's called intellectual property. I've paid for it. Ownership is mine. Now I can sell it. So if Netflix comes along and says, Jeremy, we want to buy the deposition of LIEnette, well, guess what? I have every legal right to sell it. And Silverman can buy it too.
But the notice, although it states notice of video deposition with subpoena ducis tecum, I would note there's no subpoena issued to a party, and there hasn't been a subpoena issued to a party in this case, does not contain the information about the videographer. It simply says the deposition will be taken before a court reporter and gives the name of the court reporter and a internet address for the court reporter, and that's it. And regardless of that, if their position is that the deposition wasn't concluded, my understanding is firstly that my client indicated she wanted to read the deposition. She was never provided that opportunity.
You may recall in hearing number 3, LIEnette said she did not want to go over the transcripts of her deposition. Why all of a sudden the change? As a side note, she's a party in this lawsuit. She doesn't get subpoenaed. It's an absolute. It's going to happen. Just like Silverman didn't subpoena me, and I have to go and take a deposition tomorrow.
And just yesterday, Mr. Hales, in one of his many monetized YouTube videos, plastered that video deposition all over YouTube to his 700,000 subscribers.
We should probably be a little bit more precise since we're in court. You know, schematics is everything. It's released to the world. No, wait, Judge Craig, I'm sorry. the planet.
Which is highly problematic.
How could there be a problem if we're all interested in truth? And in that deposition, she literally says, I don't lie. That's the thing. I don't lie. So where's the problem? We all want truth. Oh, it's the pending criminal charges.
So, Mr. Shockett, while we're talking about your need to redepose an individual who midstream during trial, who your co-counsel only needed 15 minutes to call 2 witnesses, possibly his own client, argue the case and cross-examine, so that would leave, I'll be generous, leave maybe 10 of those 15 minutes to cross-examine, has now taken several hours of deposition. You have, as his co-counsel. It's not complete. It's now broadcast. Do you agree that it's been broadcast on your client's YouTube channel?
I think I've seen a portion of it, yes.
Okay, well, let's talk about then whether the deposition in video format was in conformity with 12310B4, and whether in conformity with that rule, you've safeguarded the videotape. And clearly the language of videotape is now whatever format it's otherwise recorded in, inclusive of that.
This safeguarding of the videotape, the deposition, is an archaic part of the law. It's referring to VHS tapes. And it was the attorney's responsibility to actually hold on to it, to not make sure it doesn't go to others, to actually give it to others. It was the attorney's responsibility when others wanted it to say, here's a copy, here's a copy, here's a copy. That's what safeguarding meant. It wasn't nobody gets to see this in the law. It's everybody needs to get it, and the attorney who took it safeguards it. And where's the safest place for this deposition? Obviously online, on YouTube. As a matter of fact, I think my attorney and myself have gone above the law in regards to safeguarding this deposition.
The rule as I read it, correct me if I'm wrong, the attorney for the party must take custody and must safeguard it. So sharing it with your client, obviously you need to do that to get him prepared to proceed. Right. Not a problem there. What did you do to safeguard, to assure that your client, who testified or has made it clear to this court that his I don't know if it's his main source of income, but his source of income is monetizing YouTube videos. That's what's contained in the underlying this entire case, and you hand it to him. And are you on notice that your co-counsel has already, in violation of the Supreme Court order on no prohibition against dissemination, and in violation of our Chief Judge's Eighth Circuit order, prohibition against dissemination, despite attesting to that fact, your client has now monetized the posting of unredacted court proceedings from 1129 and 12:6, resulting in a lot of collateral problems directly caused by that.
Seems like everybody in this courtroom knows more about my life than I actually do. What does monetization on YouTube have to do with anything? And what does it even mean? And how do they know it's monetized? And how do they know what my main source of income is? They've heard nothing from me. Literally nothing. Except my freedoms are being taken away. Speech, you know that in this court because I haven't said anything yet. But I'm fighting for freedom of speech. I'm putting all the public information out there. Access to all my property, and the way to get there, the public road.
So you know that your client has previously disclosed unredacted videos.
Exact same as redacted videos, which is public information.
You know that your co-counsel is answering to the Chief Judge in contempt proceeding. It would have been concluded yesterday, but your co-counsel was afforded another continuance because he's somewhere and unable to appear in court, and that'll happen next Monday. That's just another side note of accommodation.
Sounds like a side note of bias.
But that being said, in that context and in context of this rule of safeguarding the attorney's responsibility, you provide it to your client, and now you know that it's posted on YouTube.
And I'll have a discussion. I will have a discussion.
What steps have you taken to safeguard and to limit the continued publication of the 1129 and 12:6 unredacted recordings, audio and video of this court?
I can't get an attorney-client privilege. But
you don't have to answer that. Did you tell me? Have you done anything?
I have discussions, yes.
Has it been unsuccessful?
And with Mr. Feather, although he's in the Philippines, I've had discussions about it. And
will you agree that it's been unsuccessful to date?
I would agree.
Since Judge Craig Thomas is going round and round again, I better emphasize this just one more time. Redacted, unredacted, in all 4 hearings, exactly the same. No changes. Public information. And deposition, I own it. It's mine to do as I please with. And safeguarding is so that it could be given to other people, not to keep it from being viewed by other people. The judge has a very odd, and I don't use that term often enough, sense of this law.
Here's the relevance of that question.
I would agree.
The relevance is, I have to consider that when you say I want to continue to depose her.
Understood, Judge. If the court so pleases, either way, but I understand your ruling. If you want to overturn the ruling allowing your deposition, that's, if the court so pleases, that's your prerogative. I felt we
Well,
need to
it's
take...
not my prerogative, it's my discretion because it's granted to the court
Right.
under 1310, which is 12130, subsection 2D. The court, at any time, on motion of party, deponent, or upon showing that the exam is being conducted in bad faith or in such a manner as to unreasonably annoy, embarrass, or oppress the deponent. How about setting a depo that doesn't comport with and comply with 12.310B4, rendering it making it a video depo when it's not in compliance with the video depo rule, and then having it published on the internet in a case of cyberstalking that's now gone on since September? How is that not the consequences of now disclosing that video on YouTube, internet, bad faith, or in a manner that might be considered unreasonably annoying or unreasonably embarrassing or oppressing the deponent? So I haven't denied you to take the depo. I'm asking you, why should I allow it to be continued?
Well, that's a different question because of what happened in the deposition, Judge.
All right, so let's start with, do you agree or disagree that the notice of the deposition that was taken by video as opposed to just audio was proper or improper?
It was technically in compliance. It said video deposition. The court reporter's name was listed on there. I guess hyper-technically it didn't say videographer instead of court reporter, but it clearly said notice of video deposition. It gave the address. The only thing it didn't say was stenographer or videographer. It just said court reporter.
So the hyper-technical requirements of 12.310, as you put it before, have not been complied with.
That's correct.
So the notice was inadequate. The result of that is that you got video footage for your client to publish and to make money on.
The only person in court that has ever said I'm making money is LIEnette. So apparently he is still taking everything she says as truth because that's the law. Truth is, I'm over $80,000 in the hole on this all right now, just on legal expenses. Yep, I just paid more bills this morning.
I didn't do it for that reason. I did it here to show you exactly. We have it queued up here to show you what
Oh, now
happened.
you want to disseminate it in court? A
wanna
portion
play-
of the video?
I would like to play it for you, yes, Judge.
You're all right. Have, just going in my head, about 7 or 8 different objections. to
Well,
that
excuse me,
report.
we also called during the deposition, if you recall, Judge, and there was problems right from the beginning of this deposition. 7 hours, if there were 3 hours of questioning, I'd be amazed.
Okay, so let's say at least 3 hours were fruitful, despite the fact that your co-counsel needed 15 minutes to conclude.
Will he ever stop bringing up Mark Feather? This is like being in a relationship with a female. You get in a fight and all of a sudden, instead of the fight being there right in front of you, you're going back, I don't know, 10 years. Remember back in 1998 when at Thanksgiving dinner at my family's house, my dad asked you a question? It's been 4 hearings and 4 months. Get over it already.
I have addressed that, Judge. I hear you on that, really do. But after that representation was made, she made another filing on the 4th, which was sufficient to meet her burden under the clear and strong, or strong and clear evidence, which you take as truthful. That was the straw that broke the camel's back that issued the temporary injunction.
Well, not really, not really.
No?
And maybe Mr. Hales needs to be aware of this law also. As a matter of law, the court has to take what's pled in this petition or supplemental petition as true. When a petition results in entry of a temporary injunction with a return hearing, that means there's been adequate information contained within that petition to establish the imminent threat. If it's scheduled for hearing without temporary, that means there's a sufficient case to be resolved and adjudicated by the court, but the element of imminent, you can conclude, was not in the petition itself, the initial one in September, was not in the first supplemental petition, and only became adequate, legally adequate, addressing the issue of imminence in what was the second supplemental petition.
In other words, when she filed and lied and said that my lawyer tried to pay her off.
So the issuance of the temporary injunction was the result of the finding that the allegations in the supplemental petition, when taken as a whole with the previous supplement and the previous petition, established imminent risk. And thus, the court had no choice because I have to accept it as true, and so on. So,
But not subject to cross-examination yet at that point, or not, correct? So it's taken as true without any cross-examination.
right, that's why we're going to have a contested hearing with full due process post a multi-hour deposition that was not in conformity with the rule, that now is on video, broadcast for the entire world to see, that's reasonably caused embarrassment, humiliation, potential danger, at least there's allegations of that, and a huge fallout.
Video doesn't cause embarrassment or danger or anything else. This is an argument that we've heard forever. It's the same as, oh boy, it's the firearm that's responsible. Let's get rid of video. Let's get rid of firearms. No, it is the person. What LIEnette did, what LIEnette said, is what is embarrassing and what is incriminating. Has nothing to do with the video. Just like a firearm has nothing to do with the consequences when a person puts their hand on it and pulls something. It's the person. LIEnette is the one who's embarrassing herself. LIEnette is the one who has lied over and over and over and over. Literally can't stop lying.
Well, but Your Honor, what happened at the deposition is important because she took the fifth on substantive issues.
So when a pro se litigant takes the fifth, do you think they really understand? There are lawyers that make objections in this courtroom that are overruled probably 100 times a week. It doesn't mean they're acting in bad faith, but reasonably one could expect they understood. When they say hearsay, they understand the hearsay rule, but a lot of them don't, or the court disagrees with their view of it. Pro se litigant is held to the standard of a reasonably competent attorney, and reasonably competent attorneys make arguments that don't fly in the face of case law or statutory rules and rules of procedure, etc. So whether she's using it to say it's irrelevant, or using it to say I'm being annoyed, or using it to truly say it might incriminate me, I don't know the answer to that.
She absolutely knows what pleading the fifth is. Now, the judge keys in on something here, whether she pleads it because she knows it would incriminate her. In civil law, if she pleads the fifth, the judge has the opportunity and, frankly, the responsibility to understand that there's an inference of guilt. She is guilty. She won't say that she's guilty, which is why she's pled the fifth.
What is relevant for today, and I'm hearing you say, is that by virtue of her doing so, you didn't get additional responses that you would otherwise believe you should be entitled to.
Yes, Judge. And also, believe it or not, I actually took the time with her at the deposition to look at the Fifth Amendment, understand, to run the same dictionary, if you will. When she says the Fifth Amendment, what does she mean? That's actually part of the transcript.
So you're giving her advice?
No.
That would be you, Judge Craig DeThomas says, since day one, illegally, acting as her lawyer.
I said, here's the Fifth Amendment. How do you, when you say...
so you're expecting a pro se litigant? There are
she got it right,
lawyers that
Judge.
come in front of me that don't understand the Fifth Amendment.
But she got it right. She got it right. And she also said she had talked to counsel on the record about taking the fifth. I don't know which counsel that was.
You think you would be entitled to that? To get her, a pro se litigant, in front of you at a depot to disclose what would otherwise be attorney-client privilege?
No, she said it on her own. I talked to an attorney. He said this is take the fifth, and it's on the record. So she did understand it correctly. It is a problem. She made the statement under oath. She took the fifth under oath, and there's consequences to that. We don't have to, as far as this, I don't disagree that we need more time to hear our motion today. That's acceptable because again, we have a forced continuance here. Mr. Cook's depot needs to be taken. And
So, let me ask you this.
I need maybe an hour more with her.
Your Honor, I have, what was elided from the motion and memorandum they filed is that after I filed my limited notice of appearance, which did include a note not only about the continuance but about potential discovery matters, I did formally, I emailed in writing Mr. Shockett, and I did make a motion under 12.310D to suspend both depositions. Again, the deposition of Mr. Cook can be cured if they just figure out how to serve him properly. As to my client, I wasn't even aware at that point that Mr. Hales was going to do what he did yesterday evening and plaster that video all over YouTube. I kind of suspected he might do it. So I wasn't aware of that at the time that I made the initial 310D motion. That is an additional ground for my 310D motion. And before a deposition of her resumes at all, if it resumes, I think the court needs to hear that. So that I think is going to have to be left for another day, which is another reason why this case ought to be continued.
Judge, here's the problem. I already said the continuance, it's forced on us. But more important, there was a pending deposition. She agreed on the record, pro se, to continue it tomorrow at 11. We left it around 5:30 or 6. No motion for protective order was filed. Nothing was filed. And this comes from someone who, judge, as a pro se litigant, who knew to file a motion to reschedule her deposition or to continue it. Nothing was done.
So we're all on the same page. The day of LIEnette's deposition, the evening after, Josh Silverman sends an email to my lawyers and says, no more depositions. LIEnette isn't going to have a deposition. Crook isn't going to have a deposition. No more depositions. Now, he can't do this because he legally does not represent her because he hasn't filed a motion to actually represent her in court. He's here in court on this day to file a motion for limited appearance. We've already seen that in the previous video. That's it. He's only there to file a motion for limited appearance to ask for a continuance. That's it. That's all he can represent her. And she doesn't show up the next day for the deposition. And Crook doesn't show up the next day for the deposition. The judge should be going off on her and Silverman. But something's way wrong here.
Tell me
You ordered
what
it, Judge.
impact, if any, you believe that subsequent to that. So if you made that argument to me the day after, or the day after that, or the day after that, or let's say any day before your client publishes on the internet for the world to see
Planet. Let's stay consistent there, Craigie.
a video deposition that was not properly in conformity with the rule even noticed to begin with. So do you think that that has some impact on the court's determination of whether this deposition continues?
It has impact.
Okay. And it's detrimental.
It has negative impact.
Okay.
But you have to weigh that, Judge.
I'm weighing it.
Okay, all right, thank you. And again, as far as the 26th...
Well, let me ask you this too. Why are there excerpts? I look at a filing, again, late last night, which is effectively this morning before this hearing, of, it appears to be excerpts of a deposition because it's like page 5, then it's page 12, then it's page 40, then it's page 60. So it's clearly excerpts. And again, in conformity with the rules, 1310, 12.310, subsection 3, a copy of a deposition may be filed only under certain circumstances in conformity with the rules of general practice and judicial administration 2.425, and in conformity with Rule 1.280G, which would require filing with good cause and with minimizing all sensitive information. Was that done?
I believe, yeah, there's just her answers. That's why there was excerpts, Judge.
So, under, hang on a second, let me get, under 1.3103B, if what you're both representing to the court from different perspectives, understood, that the deposition previously taken, or let's call it part of a deposition previously taken, is necessary for this court to review it, then under that subsection, the court can order the complete deposition transcript to be provided to the court. And it would be conditioned upon it being under seal, and it would be conditioned upon it not being broadcast.
This judge has no control over intellectual property that I have paid for and I own. And I'll sell it. I'll sell it right now to A&E, to Netflix, to anybody that wants it. I'll sell it right now, and the planet will see it. World's Dumbest Criminals just sent us an email. They want it too.
You know, there's also the issue that, again, I wasn't at the deposition, but my client tells me, I asked her about reading or waiving, and she indicates to me that she informed Mr. Shockett that she wished to read through the deposition and have the opportunity to complete an errata sheet. That was not done. I don't know why a deposition or parts thereof are being selectively put into the court record for this court and for the public to read, when one, they're claiming the deposition has not concluded yet, and two, she has not been given an opportunity to read it and sign off on it or complete an errata sheet, at least as to the initial portion.
Diabetes is rubbing off on her attorney, Silverman. All of this was already addressed in hearing number 3 and has already been shown here on What the Hales under the playlist Otter Creek.
Mr. Zimmer wasn't here. We addressed that with Your Honor. She had until, I think, today to do an errata sheet.
She wasn't even asked. The court
Yes,
reporter
she
never
was.
contacted her.
It's on the court reporter. She gave an email address on the record, and I can find out if the court reporter gave it to her. But
And
that was on the record.
If she had until today, why was the video plastered on the internet last night?
Right, and posted.
Why
We
was it
don't-
put
we
in
don't-
this
we don't
pleading
know.
last night?
We don't know what happened with the errata sheet. I can find out. I'm sure it was sent to
But
her.
the-
I
no,
never.
but
This
we
court
do
reporter-
know, we do know that what you just said is that she still has time to do the errata sheet, and instead, a not properly noticed video deposition has now been posted, and excerpts of the transcript have been placed in the court file.
Understood, Judge. And I understand what you're saying about a negative inference as to whether the debit goes forward.
What's your sense, Mr. Shockett, as to the request in effect that if it can be continued from January 6th, that
26th?
2 weeks or so, January 26th, yeah, that if it's to be continued from that date, the court would be proposing February 9 as the date. So that's basically a 2-week continuance.
I think the fact that Mr. Schulman's here, the deposition will conclude very easily of Ms. Preston. I think that Mr. Cook's deposition can be taken in a half a day. And if he wants to take my clients, I think he can, I don't know how much time he wants for that, but I don't see it as insurmountable, except for this issue with the errata sheets. Again, we should address it the same way we did with Ms. Preston and Mr. Cook. Give a short window.
I'm sure you've noticed the TV in front of me. That TV is set up to show the judge and the court LIEnette deleting or obstructing justice during her deposition, which is now a major contention here in court. Is it going to continue or not?
Let me ask Mr. Silverman, do you have a sense of how much time you think you would need on the deposition of the respondent?
I would think I would need 2 to 3 hours, probably not even quite that much, Your Honor. We're talking about a hearing that's only supposed to last another 2 or 3 hours. And so, first of all, let me say to the court, I'm available all day on Friday, February 9th. Let me just triple check that. I'm available all day that day. The boss tells me I'm available all that day. The second thing I'll say is that at this point, unless the court specifically orders otherwise, I do not intend to have my client sit for any further deposition. As to Mr. Cook, if they can figure out how to serve him properly, more power to him. And I'll certainly accommodate that.
Crook was served properly, and his deposition started, 20, 25 minutes late, with every excuse from I've got no internet to I can't get this working. And guess who was on there? Silverman. And Silverman is not legally representing Crook. He has no legal representation. But Silverman, halfway through, not even halfway through, maybe 30, 45 minutes, says, I am stopping this deposition right now because it's harassment. What do you think my lawyer is going to do tomorrow? You think he's going to claim harassment in my deposition and stop it?
I will also tell the court and Mr. Shockett that I will do evenings, I will do weekends, if we can find a court reporter who will do that, to accommodate getting these depositions done before February 9th, and hopefully getting them done a reasonable period before February 9th, so both parties don't have to come out of pocket an outrageous sum of money for expedited transcripts. Again, I'm not conceding that my client is going to sit for any further deposition for a variety of reasons, many of which we've touched on this morning, Your Honor.
That's Brent over on the other side of the turtle meat sandwich. And yeah, I know, bowling shoes.
Your Honor, if I could, on the calendar thing, I have a case in Dade County, and it's a 2017 insurance case, 2018 case, and the court's indicated that I have a deposition of my expert, and that court indicated that it's going to go to trial in March when this expert deposition finally is taken. It's on the 9th that day. I'll leave it to you. If you want to give me something that says to this judge, I can,
Your
change
Honor,
that depo.
my client and I are willing to accommodate Mr. Shockett because he has another obligation on that Friday. I can tell the court that I can make the following Friday, the 16th of February, work, correct? My child has a doctor's appointment that day. I will have it rescheduled.
The court,
Is Friday the day we do it? Is that,
I'm sorry?
it's just Fridays? Is that how it is?
No, it's just what the court can accommodate.
Right.
The next day I was going to suggest is February 5. So that's civil trial, that's a full civil trial week. The reason why the court has those 2 days available is because the civil cases scheduled for the month of February have settled. As a result, this court now has a full day trial on the 6th, a full day trial on the 8th, a half day obligation for the domestic violence docket, a court issue meeting, summary judgment motions, and a bunch of other things. And it opened a week or 2 ago. It's 3 days of now full. The 9th is available and the 5th is available.
I can do the 5th.
Why is this judge going through his whole month agenda? Just say what needs to be said. We have this day open, or this day open.
You guys want to come back on a Saturday or Sunday? I'll be here on a Saturday or Sunday. You want to come back at midnight? We'll be back at midnight.
Whoops, that was the judge in hearing number 1. We're way past that. We're in hearing number 4 now. But he's not biased, right? Now that his buddy Silverman is there?
I have a deposition that's a regular one. I can reschedule that.
Your Honor, I can do the morning of the 5th, the afternoon of the 5th. I'm in a multi-hour hearing with Judge Fiegel in Dixie County on a child abuse case.
Interesting, since his ex-wife had charges of child abuse of their own child.
That has been specially set, so I can't move that, but I am available in the morning.
Let's go back to talking about the 9th regarding, because here's the other thing is I want to provide a little more time rather than less time, which is why I suggested the 9th first. Mr. Shockett, what's the deposition you have to take on that day for the expected trial?
It's an expert deposition. He's a University of Florida engineer.
Are you doing that by Zoom? Or?
It is by Zoom.
So you're going to remain somewhere here, not
Yeah,
having
in
to
the
go to
Trenton. Yeah. It's set for 10 a.m.
I can, on the 12th, will Strooping continue the trial? Remove that trial?
I can tell you this, that the next full day, despite the fact that, again, back on November 29, the court had previously scheduled matters for the 30th, but felt it important enough to both litigants to offer that day, and the record would reflect. I said I would cancel what I already had, and I would accommodate these litigants, and that was denied. And literally, there's not another day, and I'm just in abundance of caution needing a full day for this.
The way he and LIEnette go on and on and on, we need a full week.
Till March 1, and that's just too far out. So
I can make March 1 work, Your Honor.
Well, probably we all could, but the consequences of time that are reasonably expected based on the negative consequences to the fair administration of justice, the orderly administration of justice, the compliance with rules promulgated by the Florida Supreme Court and the Chief Judge of the 8th Circuit being violated, the court has concerns about the length of time and what might happen between now and then.
What could potentially happen? Okay, LIEnette and Crook could violate the civil protection orders from Ohio again, get arrested because of it, not be able to come to the final hearing because of it. Oh, Jeremy and George may actually share truth, actual real truth of this entire story.
It would be, and I certainly understand the court's concerns, as I indicated in an email to Ms. Cummings, Chief Judge Mosley's JA, on which Mr. Shaka was copied. I can't be here next Monday for that hearing. Chief Judge Mosley indicated that neither my client nor I need to be here, and quite frankly, we don't have a dog in that fight. That's between the courts and Mr. Feather. I will hopefully think those order to show cause proceedings have impressed upon counsel the need to protect and comply with the videos in accordance with the administrative order.
Chief Justice Mosley determined and stated in that hearing that the redacted videos, they're fair game. And the redacted videos are exactly the same as the unredacted videos. No change, no difference, nothing at all. As far as Joshua Silverman knows right now, he's watching an unredacted video. Or is he? I can't tell. They're exactly the same. I keep getting them mixed up.
Certainly, if depositions go forward in this case, regardless of who the depositions are of, I will be asking the court to impose a protective order barring any publication, period, except in accordance with the rules of procedure. So I think we could address it there. As I indicated, I can make the morning of the 5th work. I do think that's likely too soon to get everything accomplished. That basically gives us a week to get the depositions done, and I will certainly endeavor to do that, though it does look like it'll have to be in the evenings or on the weekend to get those depositions done. Alternatively, if they're okay with the 1st, I can make that work as well, and that will give both sides plenty of opportunity to conduct the discovery. Hopefully, Mr. Hale's side of the aisle has gotten the message regarding the need to safeguard witness testimony, information, and videos.
Oh, I got the message loud and clear. Legal safeguarding is holding on to that video and then giving it to others as they request it. Therefore, that's why it's on YouTube. And things are about to get heated here because my lawyer's going to drop a bombshell on her lawyer and the judge.